Hello, my name is Jon Wright, and I'm a director at the law firm of Sterne, Kessler, Goldstein Fox. The Patent Trial and Appeal Board has published on its webpage 6 representative decisions and orders that deal with discovery and evidentiary issues in inter partes review proceedings. We reviewed those 6 decisions and bring to your attention 4 important points the board wants practitioners to know. First, the board expects practitioners to know the difference between routine and additional discovery. The rules define routine discovery as that which parties are entitled to without being granted prior authorization from the board. Routine discovery includes the production of exhibits cited in a paper or testimony, cross-examination of opposing declarants, and non-cumulative information that is inconsistent with the position advanced during the proceeding. Additional discovery is pretty much everything else. Unless the parties reach an agreement, the board must authorize additional discovery, and the requesting party must show that the requested material is necessary in the interest of justice. Second, the board has clarified the interest of justice standard, and it is very difficult to meet. The board will consider 5 factors. First, you need more than a possibility or mere allegation of material evidence. You basically need to be aware of the specific evidence you are seeking. Second, the evidence sought must not be for the purpose of discovering litigation positions and their underlying bases. The board is sensitive to misuse of discovery for this purpose. Third, the requesting party should not have the ability to generate equivalent information by other means. For example, do not ask for a file history of a cited patent because you can get that on your own. Fourth, the request must be accompanied by easily understandable instructions. Litigation-style interrogatories with their endless definitions will not be tolerated. And finally, the request must not be overly burdensome to answer. Moving on to the third point, the board wants practitioners to understand the criteria and the procedure it will use for sealing documents. The board has expressed a strong public policy rationale and preference for making all information filed in an inter partes review open and available to the public. The board aims to strike a balance between the public's interest in maintaining a complete and understandable file history and the party's interest in protecting truly sensitive information. The board recommends that parties either redact or simply not submit confidential information that clearly has little relevance to the merits of the case. Procedurally, the party must move to submit material under seal. The submitting party must show good cause for sealing a document, and the motion must include a proposed protective order that conforms to the default protective order in the trial practice guide, with any deviations explained. Do not expect to rely on a protective order from a co-pending litigation. Finally, the board wants practitioners to understand the process for excluding evidence. With few exceptions, the federal rules of evidence apply to these inter partes proceedings. If a party objects to evidence that was submitted during the pretrial phase, the objection must be served within 10 business days of the institution of trial. Thereafter, any evidentiary objections must be served within 5 business days of receipt. The objection must identify the grounds for the objection with sufficient particularity to allow correction in the form of supplemental evidence. If, upon receiving the supplemental or corrected evidence, the opposing party still believes the evidence is inadmissible, it may file a motion to exclude in the time frame set by the board. It is not appropriate to lodge objections to evidence prior to trial initiation. To summarize these points, the board's discovery and evidentiary guidance reflects the fact that the federal rules of civil procedure do not apply to the new post-grant proceedings. Discovery is extremely limited because of the short time frame for the proceedings, and there's a strong tilt towards full public disclosure. Implicit within all of the board's decisions is the preference that parties resolve discovery and evidentiary disputes among themselves, and should only resort to the board's involvement as a last resort. Understanding the board's guidance will ensure a more efficient proceeding for you, and most importantly, your client. Thank you.